Okay, you should be able to begin.
All right. Okay, thank you. Please do call the case now.
Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled State of Vermont v. Willard Buell, case number 25 AP 331. Representing the appellant, Willard Buell, is attorney Lamar Enzor. Representing the appellee, the State of Vermont, is attorney Artemis Richardson.
Thank you very much, and good morning. Good afternoon, counsel. Before we start, I just want to alert you, I've had some trouble with my Wi-Fi, and in Rocket hearings the other day, some delay of probably
We're having the problem again, Chief.
5 minutes.
If you're breaking up a little bit on your
Breaking up.
end of freezing.
Rejoining by phone. So same thing with
Yes.
the hearing. And Justice Eaton, if I get bumped off, please take over.
Okay.
And I'll call in. Okay. Attorney Ensor, please introduce yourself and your client, then go ahead.
Thank you, Your Honor. I'm Lamar Enzor, and I represent the defendant in this appeal, the appellant, Willard Buell.
Thank you. Please go ahead.
Thank you. This is an appeal from a determination by the trial court of a hold without bail under 7553 based upon the allegation set forth that the defendant is or has habitual offender status. We held a hearing on this with the trial court in which the defendant appellant put on evidence from a witness who is related to the defendant by virtue of marriage to a daughter who is actually related to the alleged victim in the case. In any event, the witness is personally aware of the circumstances for Mr. Buell, in particular, the fact and the need for continuing medical treatment, and the witness was able to testify at the hearing about medical treatment that Mr. Buell has had in the last year, in particular related to his esophagus, but also with regard to surgery that was scheduled in July of this year that did not happen because of his incarceration on some initial charges for violating abuse prevention orders. The purpose of the hearing and the arguments presented at the weight of the evidence hearing on behalf of the defendant was that the defendant needed to attend to the immediate circumstances of his medical situation. Surgery is contemplated for his leg related to a clotting problem, and it could have dire consequences for him in the future if he does not get this surgery moving forward quickly enough. The witness was personally aware of this because he actually lived, along with his wife, with the defendant and his then wife prior to all of this happening. And so he was able to speak from personal knowledge about Mr. Buell's medical situation. The unfortunate circumstance is that the medical providers were not exactly responsive or enthused about, let's just say, diving into this type of situation beyond what would be contemplated for medical purposes. So the witness we presented was the only one available who could testify from personal knowledge about the situation. In addition to that, we also presented testimony at the hearing that the witness and his wife were appropriate as Condition 4 custodians under conditions of release, such that Mr. Buell could reside at their residence, which is in a trailer park. It's in Pownell, Vermont. As I recall, the trailer park section that the witness and his wife live in is not technically the same as the section that the alleged victim and the residence where the defendant is in, but they're in close proximity, roughly 300 feet or 100 yards or so. There apparently also, according to the testimony, was no need for the defendant to travel by or near the residence of the alleged victim, such that it might interfere with any conditions of release for no contact or condition 15 for no abuse or harass. So we felt that the arrangement and the understanding of the witness and willingness to have Mr. Buell reside with him and his wife would be sufficient, along with conditions of release, to protect the community as well as reasonably assured attendance in court in the future. The trial court disagreed and held him without bail, without access to the residence put forth at the hearing. The defendant would, in essence, have no alternatives in terms of a designated place to live. There would also be a curfew requirement imposed, and the curfew again would add more protection for the victim as set forth in our arguments in the trial court. So we're asking this court to review, and I know my client was adamant for this court to review the situation, look at it again, and we're asking this court to impose appropriate conditions and or order that the defendant be held on appropriate conditions, could be including bail too, as appropriate, because currently he's being held without bail.
Okay. Thank you very much. We'll turn to counsel for the appellee. Please introduce yourself and your client and then proceed.
Good afternoon, Your Honors. My name is Artemis Richardson. I'm a deputy state's attorney and I represent the state of Vermont. First, I'd like to address the defense's statements very quickly about the state of the case. In this docket, which I believe is being appealed from 25 CR 09077, although the defendant is an habitual offender, the basis of the hold under 13 VSA 7553 is not his habitual offender status, but the fact that he is being charged with several life offenses, including 2 counts of sexual assault aggravated with serious injury and sexual assault with no consent.
That distinction make a difference in terms of the court's approach?
No, Your Honor, I just wanted to make sure that the situation was being reflected accurately.
Right.
Under 7553, the presumption would be a hold without bail, and at the hearing with the trial court, the defense stipulated to the weight of the evidence there. The standard of review for the 7553 is de novo, but the standard of review for the withholding of discretionary bail, which I believe is the defense's primary issue here, is for abuse of discretion. And that's from State versus Buell, 2020 Vermont 106, paragraph 13, citing State versus Orost, 2017 Vermont 110, paragraph 6. The trial court examined the defense's arguments at that time and found that the defendant's criminal history, because he is an habitual offender, the level of violence and the alarming nature of the charges, the element of obstruction of justice, and the close proximity of the proposed condition 4 location all combined to show that an exercise of discretion was not warranted in this situation. And finding dispositive the defendant's criminal history and his character and mental state at that time. The court heard and considered the defendant's medical issues, but as the court correctly pointed out, and at the trial level hearing, the Department of Corrections is obliged to provide all necessary medical care. We didn't hear from any medical professional that testified that there was some necessary procedure that the defendant needed to undergo. But even if there were, the Department of Corrections is obliged to provide it, and there are ways to provide that without lifting the hold without bail. The defendant does not need to be released into the public to receive the necessary medical care that he requires. And if he is not receiving necessary medical care, the appropriate redress would be, he would certainly have grounds for civil action against the state, but release on the hold without bail would not be the appropriate remedy in this situation. So the state asked this court to affirm the holdings of the trial court, Your Honor, and that is the state's argument.
All right. Thank you, counsel. Counselor for the appellant, anything more?
Just one brief point, Your Honor, thank you. That is that we did present by proffer with no objection at the trial court level the fact that the defendant had presented to the Department of Corrections a number of more than a dozen requests for medical assistance and requests for update on his surgical status, and he was not receiving any response from the Department of Corrections. But with that final point, we would conclude our argument.
Okay, thank you both very much. Please call a conclusion of the hearing.